The first thing I'll say is I'm going to put a longer and arguably duller version of this speech on my Substack, and I think Genspect will also be publishing it. So if there's any of the court references or court judgments that you're interested in, I'm going to have a light touch with references and quotes. You'll be able to find them there. The second point to make is that I'm going to go a bit off-piste, and that was because I was inspired by Bev's palpable rage yesterday. I was going to give you a talk about how it's all lovely and there are green shoots for optimism and things are changing in the courts. I didn't want to be really negative. I didn't want to instill fear and loathing. But I think I was wrong to take that cautious approach. The fact that the law and medicine of all the professions fell to this is utterly shameful. Because they, of all the professions, have their fundamental ethical foundations based upon evidence. So I think we should be afraid at how quickly and how far they fell. And while hopefully I'll be able to talk you through how I think we're coming out of that doom spiral, the fact remains it should never have happened in the first place. And there are questions, really serious questions, to be asked about how both these institutions were captured so completely. The nearest parallel, the only parallel I can think of, is the satanic ritual abuse panic. But even that did not have the worldwide scope, contagion, and reach of gender identity. So I'm still puzzling as to what has gone wrong. And I hope my quick canter through the court's response might give you some indication and some things to think about. My talk's entitled The Battle for Children's Capacity. Children are really, really important to the gender identity movement for obvious reasons. The first is, if you talk about the vulnerability and the helplessness and the suicidal ideation of a child, you can bypass a lot of rational thought. How dare you criticize our rush to affirm this child, you monster? Would you rather have a live trans child than a dead child, etc.? So it's that appeal to emotion is really powerful. And the second, of course, is that it allows the middle-aged biological man or the convicted rapist to suddenly decide that this is something innate. They've always been a woman. This is something they were born with. You cannot criticize or challenge them for that. So the battle for children is a very important part of this identity and how it's gained a hold. So these are some of the themes I want to be looking at, if I can work the clicker. As with all of Gen X, who are the preponderance of the speakers, I cannot work technology. Oh, it was the other arrow button. Sorry about that. I blame my identity as incompetent. So these are some of the themes I want to touch on. I mean, making decisions about those who lack capacity is always an artificial exercise. You are always imposing your own view of what you think is best for somebody. This was the bit of the speech where I was going to try and exculpate the legal system and try and explain why I think they got it so wrong. And I think there's still value in that exercise. The first thing to note is, of course, the limits to lawfare. There are the very obvious wider limits, which we're seeing now. The very clear victories that have been secured in the courts in England and Wales have not translated into a change of culture. People are simply ignoring the law. That being said, I'm still a big fan of lawfare because I have to remind all of those of us who come from England and Wales, if this conference was happening in London, if Maya Forstater and Harry Miller had not fought and won against the first instance decisions that condemned them as not worthy of respect in a democratic society and hateful, we would all be under risk of arrest. And that is not hysteria or hyperbole. That is the reality. So lawfare was absolutely essential to claw that back. Where I became naive was thinking that that would be an end to the matter and we'd all get back to common sense and reality. We didn't. And clearly what we do need to look now is beyond court victories and instilling a change in culture. And that's going to be a difficult shift because obviously gender identity, I think, has been at least 3 decades in the embedding. The more particular difficulty about lawfare, and what I'll be focusing on more here, is the limitations to the court process itself. The court is not a public inquiry. The court can only decide the case in front of it. It can only decide the evidence that the different parties bring. So if the parties put up a duff case, or indeed has happened with quite a few cases around gender identity, the court's been presented only with parties who are all in agreement about how wonderful it is, it gives the court little wiggle room. And I'm going to touch on Bell and talk briefly about why that judicial review was overturned, and it's very much to do with the limitations of the court process itself. One of the biggest problems that the court has had is an understandable reluctance to accept that both parents and doctors have gone mad. Oh, sorry. And this was going to be part of where I tried to be really gentle and kind to the courts. But seeing and being inspired by Bev's rage, I thought, look, even if you don't have any children yourself, you remember what it was to be a child. We don't let 12-year-olds get tattoos or vote for a reason, because they're stupid. So the fact that any judge can pontificate about, we must listen to the child, that the child says they were born a girl but they're really a boy, and I'm not going to question that, is insane. I don't know why judges stop listening. It may help, therefore, to have a look at the theory behind how the courts deal with children in capacity. Oh, there we are. And this may be quite helpful to those of you in England, Wales, who are dealing with these issues and want to have a brief overview about what the court does about it. The theory is quite straightforward. There are 3 categories of capacity cases. If you're a child who's under 16, then you can decide to do terrible things to your body if you have what's called Gillick competence. And this comes from the very famous case of Victoria Gillick back in 1986, who challenged a doctor's right to give her 15-year-old daughter advice about contraception on the rational approach that the age of consent to sexual intercourse was 16, so no doctor should be encouraging her daughter into a criminal act. The House of Lords, as they then were, they're now called the Supreme Court, were very clear that as children grow, obviously if they're neurotypical and not with any brain injury, we can safely assume their understanding will extend, as does their chronological age. So if you have a child under 16 who can understand the risks and benefit of a treatment, they may consent to it. And the parent's right to intervene or deny becomes a dwindling right. And that dwindling right virtually disappears entirely when the child gets to 16, because we have Section 8 of the Family Law Report of the Family Law Reform Act of 1969, that says children of 16 have a presumed capacity to consent to medical treatment as if they were adults. Now, immediately, we can see some problems with that. That's quite an old act now, even older than I am. And what we now know about the maturation of the adolescent brain does put gravely into doubt 16 as the benchmark for this kind of presumed capacity. And indeed, that's even reflected now in sentencing guidelines. If a young person commits a criminal offence and they're under 25, they will get time off their sentence on the basis they didn't know what they were doing. So I think this has actually been a real stumbling block in the court's ability to respond effectively, in that, of course, the courts are bound by the statute, and that's what the statute says. There is a glimmer of light, however, with the 3rd category. The High Court has overarching inherent jurisdiction to override any child's consent if there is a risk of significant harm, and to do so is in the child's best interest. This is a very ancient jurisdiction, the parens patriae jurisdiction. So there's a window there. If you're really worried about a particular 16-year-old child, you could ask the court to determine that treatment fell into a special category. So that's the theory, and we need then to look at how the courts respond. So again, I'll try and be gentle with the courts, because it's clear that they were presented as a fait accompli with this creature known as the trans child. Now, judges obviously are not doctors or psychiatrists. In very rare instances, you may be dual qualified, but generally, they rely on experts to come to them and tell them what's what. So by the 1990s in the UK, parents of gender dysphoric children began to require hormone suppression at the first signs of puberty, because it's considered puberty blockers administered at such a young age, as you know, would allow the child to pass more successfully as an adult. In 1997, we had the European Court looking in the case of X, Y, and Z, that transsexuality, as it was known then, raises complex scientific, legal, moral, and social issues in respect of which there is no generally shared approach amongst the contracting states. By 2007, we had the Yoja-Carter Principles, which spoke about the deeply felt internal experience of gender. And around the same time, the Department of Health and the Endocrine Society in the UK developed new guidelines recognising the sense of gender. And as Dr. Cass noted, all of this is happening alongside a shift in the model of medical care, which used to take a very narrow basis of just ensuring physical, robust health with a good evidence base. That's increasingly being seen as unacceptably narrow, and instead medical care is now apparently to involve helping a patient's sense of self-fulfillment. And I think Dr. Cass has noted that the dangers that that brings. And then, of course, we had the explosion of referrals to the Tavistock. There were just 97 in 2009. I think a mere 7 years later, that was over 2,000. And in 2015, Stonewall added the T to the LGB. And we end up in 2024 with high-profile lawyers such as Jolyon Morn, KC, making dire predictions about parents tipping out the ashes of their dead trans children on the doorstep of number 10, because the risk of suicide is now going to explode, given the NHS's welcome intervention. And from my own experience, I've been doing this for about 30 years now. In the first 25 years of practice, I saw not a single case involving any whiff of any child with a claimed trans identity. Since then, I've had 6, and 3 of them have, surprise, surprise, involved teenage girls with extremely serious histories of trauma and abuse, including sexual abuse. So that, I think, is an interesting anecdote about the shifting field. So I do feel some sympathy with the courts. They're effectively presented with a fait accompli by the experts. The trans child exists. And we even have Mr. Justice Francis in a case this year still opining that it's incredibly rare in a case where doctors and parents agree that the court has any legitimacy to intervene. That goes back to my earlier point. There's just general reluctance to accept that professionals and parents have gone mad, and they have allowed an ideology to cloud the real love that the parents have for their child and the reliance upon evidence-based medicine that the clinician should have had. So trying to put all that together, how's it been working out in practice? So here's my original optimistic slide. Well, it wasn't great, but it's getting better. And I do firmly think I should have put more of the focus on just why it wasn't great and how badly it wasn't great. But let's take you through a brief canter through some of the decisions from 2016 to the present date. In 2016, we had a very interesting case involving a child who was 4 years old. Now, this 4-year-old child, apparently, according to his mother and to mermaids who sat with the mother in court, disdained his penis and wanted to be a girl. Now, everybody in that case went along with it, including the local authority. Mr. Justice Hayden was highly critical of the local authority for getting swept away in this prevailing and false orthodoxy. And he commented, and I think this is worth reading aloud, "This local authority has consistently failed to take appropriate intervention where there were strong grounds for believing that a child was at risk of serious emotional harm. I propose to invite the Director of Children's Services to undertake a thorough review of the social work response to this case. Professional deficiencies to this extent cannot go unchecked if confidence in this local authority's safeguarding structures is to be maintained." Now, that all sounds great. The court was doing what the court was supposed to do, be a check and a balance to the fad that has swept through all the child protection agencies in this poor little boy's life, which nearly led him being set on a path of social and then, I assume, medical and surgical transition. But it also highlights exactly what I referred to earlier, that lawfare isn't enough, because this very sensible and entirely correct judgment, fast forward to 3 years in 2019, and we have the frankly astonishing case of Lancashire County Council and TP and others. This case involved foster carers who had 2 unrelated children in their care. At the ages of 4 and 7, both these little boys were said to wish to transition to be female. There was a lone voice of concern, the children's guardian, but that was quickly squashed by the judge And it's quite an interesting judgment to read because he's clearly patting himself on the back throughout at how modern and forward-thinking he is. And the judge said this, and again something I think is worth reading out. Notwithstanding even the guardian's caution in respect of the openness of the foster carers to the possibility of an alteration in the children's attitude to their gender identity, remember they're 4 and they're 7, I conclude that Dr. Pastersky, she crops up a lot, Dr. Pastersky's evidence demonstrates that it is obvious that neither of those grounds would meet the threshold for state intervention. Taken together with the panoramic evidence of the child-focused approach of the foster carers, it is overwhelmingly obvious that neither H nor R have suffered or are at risk of suffering significant emotional harm arising from their complete social transition into females occurring at a very young age. The evidence demonstrates the contrary, that this was likely to minimize harm. Now, that's an absolutely remarkable assertion for hopefully many obvious reasons to everyone in the room. That the first obvious reason, there was not a jot of evidence that this was overwhelmingly in their best interest. There was no cohort of children before this judge who'd been socially transitioned at the age of 4 and gone into adulthood. There was no information about their ability, as has been so poignantly said, to love and to work. It was entirely on the assertions of Dr. Pastersky. And of course, as we now know, the judges should know from what Dr. Cass has said, social transition isn't neutral. Social transition is a serious psychological step and should only be done carefully and in conjunction with expert advice, none of which these poor children had. And it's one of the great deficiencies of the job that I do, is we don't get data, we don't get follow-up. I don't know what happened to those little boys, but I'm guessing it wasn't anything good. So there we have it, a failure not just of the courts, but the failure of lawfare more generally. A very sensible and robust decision in 2016 is thrown entirely to the wind when we get to 2019. But then, of course, we had Bell. Now, Bell blew the doors off. What Bell revealed was utterly horrifying. And I think this is what led the divisional court into error, because they were so shocked by what that case revealed. The fact that the Tavistock thought it was a positive element of their case to bring in a young child who, when asked about relationships in the future, basically said, ugh, that's not something I want to think about. Well, no, because you're 10 or you're 12. Of course you don't want to think about it. And the Tavistock, for some reason, thought this was a positive. So the divisional court reacted with horror and set up a scheme whereby any attempt to medically transition a child would effectively have to go through a court filter. And that's why the Court of Appeal intervened. Not because the Court of Appeal dismissed any concerns about the efficacy of medical transition, but because the action brought against the Tavistock was a judicial review. This is a very particular and narrow type of legal action, which challenges the lawfulness of acts or omissions of public bodies. It was not an invitation for the court to set up its own structure of medical intervention. That would be impermissibly interfering with clinical judgment. That would require the intervention of Parliament. So I think the Court of Appeal were quite right to intervene. But it did show a power of lawfare. You don't necessarily have to win your case for it to have quite significant and amazing ramifications. And Bell really was the beginning of the end for gender identity in the courts, because politicians shared the judges' concerns, and Bell led directly to the commission of the Cass review, and thankfully you see where we are now. So massive congratulations and thanks to all of those who are actively involved. I think 2 of them are in the room with us right now, so thank you very much. And okay, it took a little while for the penny to drop, even after Bell, because in 2023, we had the president of the family division saying it was absolutely A-OK to send a 15-year-old girl out of the country to get her tits chopped off because she was highly settled in her identity as a boy. It didn't seem to occur to the president that she had to go out of the country for that operation because it's illegal in England to remove a child's breasts, even however much they say they want it to happen. So there was the usual guff about authentic identities and very, very clear. That I thought was a very disappointing judgment. But then an interesting sea change has occurred much more recently, because the Cass review finally came out and Gender GP dramatically overplayed its hand. Because fast forward to 2024, and interestingly, this is the president again. So the man in 2023 who was absolutely fine with sending a child off for a double mastectomy suddenly realised that attempting to kill a child with an outrageously high dose of testosterone, as Gender GP attempted, was not a good thing. And he delivered judgment in the case of Ree J, which came out shortly after the final version of the Cass report. And it's doubly interesting because there was no need for that judgment. The parties had actually agreed the way forward. The teenage girl was going to go to a 6-month assessment with Gender Plus. They are now the only gender clinic which is regulated by the Care Quality Commission. And that also is under attack by a judicial review, and I hope they are stripped of their registration. But at the moment, they are offering a beacon of hope in that they profess to put talking therapists first. So the parties had come to an arrangement. But I think what Gender GP had done had so horrified the judge that he delivered a published judgment about it. This child had been given a dose of testosterone that was so high, the expert endocrinologist reporting said it could have killed her. Another endocrinologist who reported to the court said, but no, the limits are fine. The level of testosterone in his blood are fine. Yes, for an adult male, they were fine. But this was a 15-year-old girl. So there was real concern. And the court said quite clearly, any parent who goes to Gender GP, then we are going to see ourselves in that third category of cases where the inherent jurisdiction will be invoked to stop that happening. Barely a week later, we had a further judgment in a case where I represented the mother. And that was a very interesting case because the mother's child at the time of the judgment was 16, and obviously we can see why that's significant. But the legal proceedings had begun a few years before, and the court had been very willing to injunct both the parents against going to get puberty blockers. So clearly that's a very welcome and quite massive shift in the court's attitude. The problem that we had, however, was by the time it came to the final hearing, the child was 16. So remember what I said about the Family Law Reform Act. That meant the court seemed to feel its hands were tied. And I made lots of impassioned submissions about the need of the court to protect the children. What was the point of this jurisdiction if you weren't going to use it? Because there were some very odd and concerning things about this case. The first was that the child in question was living in a sexual romantic relationship with another girl who identified as a boy. That child was the daughter of the first child's stepmother who lived with her dad, and they were all in the same household. It seemed to me the risk here of contagion was very, very high. But the guardian appointed for the welfare of the child wasn't remotely concerned about that. And I'll never forget cross-examining the guardian about the issue of fertility, because a great deal of weight was put on the fact that the child was certain, the child was sure, the child had done a lot of research. So I said, so what questions did you ask about the issue of fertility? Well, I'm not going there, that's a bit horrible. The look of distaste on both the judge's and the guardian's face was interesting. And I've just suddenly realised I'm probably in contempt of court for saying this because I'm referring to something that's happened directly in court proceedings, but there's a published judgment, so I will do my time, because I do think both those points are very interesting and reflective of the difficulties that we're seeing in these cases. But the really good news about that case is the same arguments were put to the Court of Appeal, who have agreed that they are compelling arguments. So that case is going to appeal. I think Jeremy Hyam KC, who represented Kira Bell, is going to be taking that up. So I'm really hopeful that there may be an even bigger shift. But it takes me back to the point I raised at the outset. It should never, ever have happened in the first place. And I'm not going to gussy it up with optimism about green shoots. It's all been about 20 years too late. And to me, it's a really sobering reminder that the structure and the safety I put my faith in and I thought existed is not real. And it doesn't take much to tip it over the edge. And that's been a really horribly sobering realization for me now in my mid-50s, that what I thought was the arc of human history, that I could rely on the integrity and the professionalism of those in charge of such important areas as medicine and law, I no longer have that faith. And I suppose it is always better to know, and I don't want to be hugely negative, things are getting much better. The fact that this case is going to the Court of Appeal at all is wonderful. And I hope the Court of Appeal will give it a very sober and detailed judgment, and it will be further impetus to try and bring about this change in culture that's so desperately needed. I appreciate that lawfare has its limitations, but it is also a necessary tool in our armoury. So I hope that made sense. And obviously, if you're interested in any of those cases, I will publish all the links and you can have a read for yourself. And I think I've got 5 minutes if there's any questions.
We have a question right here. Would you like to stand up?
Thanks. So, Susan, it's not so much of a question, but I'm really pleased that you mentioned the CQC case. Glutton for punishment that I am the person that yet again is going to take a judicial review on this. Curiously, I put it on my Twitter, Sue Evans Protect, where I put my original case that became known as the Bell case. But apart from someone named Neville Thropes, who religiously reposts it every other day, it seems, it's sort of rather sunk. And so I just wanted to say something about it, because I think in the UK, we are lucky that we've made some progress, as you say. But I also think that the private area, and I'm sure this applies, in other countries too, but the clinic, it's the challenge for the CQC who've granted the license to the clinic. But I think we've got to keep finding ways to close the doors, because each time you do one thing, the next bus comes along, and we've got to be creative about how we tackle it. So thank you so much for all you do. You are amazing at the work that you've been doing, and I think we should give you a round of applause for that. And just to thank the people that have contributed to the fundraiser, but it's on my Twitter, as I say, and we're just waiting to hear back from the court. So we've got the papers in, we're waiting to hear. So
well,
anyway.
Thank you very much for that, and obviously right back at you. When I put this on my Substack, I will put links to the fundraisers, and I know people are getting very tired now of the fundraising. But the cultural shift that we need to enforce is symbiotic with the lawfare that we need to achieve. Because as I say, otherwise we would all, in England now, be under the risk of arrest. And that is not a fanciful or hysterical assertion, that is a reality. So I will put those links up, and I urge people, if you can just drop £5 or £10 into this. And as Sue says, we need to cut this off at the knees. The fact that Cass felt that she had to talk about clinical trials for puberty blockers for children who cannot consent, and there is no evidence to suggest that a research trial would bring any benefits, is very worrying, and it shows how deep the roots of all of this are. So please do check out the links, and if you can give £10 to either the fight against the registration of Gender Plus or the continuing case that's going to the Court of Appeal, that'd be really appreciated.
Another question?
Hi. So I think your talk has really brought several things together for me, namely the fact that trans ideology not only causes problems, in its own right by forcing institutions and society to clean up the messes made by gender doctors who make false promises to their patients by attempting to medicalize their false metaphysical claims, but also what has become very clear to me from your talk is that gender ideology, when it captures institutions, it basically subverts and hijacks the ability for any kind of safeguarding organization to do its job. Like when you were talking about the case of the little boys, what's really crazy to think about is that instead of wondering about, this child who has disdain for his penis, the fact that nobody had the thought of, I wonder if this child was sexually abused. They thought trans first, and so as a result, it's become very clear to me based on your talk that the invasion of gender ideology into courts has made safeguarding institutions basically null and void, not only because of the demands of gender ideology, but because of the wool it pulls over everybody's eyes. And so, my question to you is, do you have any idea of how the courts became so ideologically captured? Like, are there specific points of vulnerability within these bureaucratic institutions that make them prone to ideological capture?
I hope I touched on that briefly, just with the inherent limitations of lawfare. Judges are not experts. It's garbage in, garbage out. If there's somebody with an impressive sounding title who says, what this 4-year-old kid needs is to disdain his penis, the judge goes, well, I'm no expert. So there's that weakness. The weakness I probably didn't touch on is why this ideology has been so successful, because it has piggybacked very much on other civil rights organisations, most notably gay rights. And the self-congratulatory smugness of Mr. Justice Williams, and I name you, in TP, is a sight to behold, really patting himself on the back about how forward-thinking he was, not like these other fuddy-duddy old judges. You know, I'm really with the programme. And that, I think, is very powerful, because we all like to, you know, our sense of pride to be appealed to. We're the head of the curve, we're cleverer than you, we're at the vanguard of this new thing. So if you bundle together the institutional weaknesses of the court process, garbage in, garbage out, our own arrogance and our need to be affirmed as knowledgeable, and I suspect judges are probably more prone to that than many other people. And that's how it's happened. So just in 3 years, from Mr. Justice Hayden to Mr. Justice Williams, you see the complete collapse of the child protection system. And that should be horrifying to all of us. I don't know precisely what happened, but I think those broad themes came together, and then that's where we ended up.